Three, two, one.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, gentlemen, and welcome to the Court of Appeals. We're doing something, at least from the perspective of the judges in the Western section, is fairly unique. The courthouse is closed and we're holding oral arguments, all because of Zoom. We just didn't realize what a blessing the pandemic would be. I hope each of you are staying warm and staying safe and trying to avoid the weather. But we certainly appreciate you participating via Zoom. We appreciate you making yourself available today. And we appreciate Mr. Hivner and the efforts of his staff and the AOC to make all this possible. In just a moment, we're going to begin oral arguments. Please keep in mind that the procedure that we are utilizing is the same procedure as if you were in the courtroom. And we will observe all of the same rules that we would as if we're there. Before we start, I want to introduce the panel to you today. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Obviously, all of you are experienced practitioners. You know how the system operates. Each side gets 15 minutes to make its oral argument. If you are the appellant and you've reserved time with Mr. Hivner, you will get that rebuttal time after the appellee argues. Mr. Hivner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Carol Buckley versus the Elephant Sanctuary in Tennessee, Inc.
We will hear from the appellant.
Thank you, Your Honor. May it please the court, Justin Adams and Ed Yarbrough on behalf of the appellant Carol Buckley. Your Honor, the facts of this case are fascinating, to say the least, but I want to focus on what I think is one key fact and three basic legal principles that I think should govern the outcome. The fact is that the trial judge stated unequivocally why she granted a new trial, and that was the erroneous comment in Ms. Buckley's closing argument. The three legal principles are as follows. The first is the principle that a litigant cannot hold an error as an ace in the hole, is the terminology this court's used in the past. If you have an error that you think warrants a new trial, you need to use it or lose it. And then the second principle reinforces the first, and that is you can have a mistrial or a curative instruction for that error, but not both. And then the third principle reinforces the second, which is a jury is presumed to follow the instructions of the court, particularly curative instructions, absent clear and convincing evidence. The trial judge's decision to grant a new trial in this case didn't take into account any of those principles. First, the trial judge did not address the presumption that the jury was presumed to have followed her instructions. She didn't address that principle. The argument was made, she simply didn't address it. There was no evidence put into the record to show that the jury had not followed her instructions. Certainly not clear and convincing evidence, but no evidence at all. The second principle was not acknowledged either.
Let me ask you a question, Mr. Adams. In this case, a curative instruction was given to the jury. Is that correct?
Yes, Your Honor.
And does the trial judge, after a curative instruction has been given and after the verdict has been rendered, have the discretion to grant a new trial based upon its analysis as the 13th juror?
Yes, Your Honor. The court certainly always has the right as the 13th juror to reject the jury's verdict. The difficulty in this case is that the trial judge made it clear that's not what she did. At first, that was the impression, that's what she did. But on the record, in order, speaking through the order of the court, the trial judge said, in fact, she had granted the new trial based upon an error, not based upon her assessment of the weight of the evidence. She wasn't exercising her 13th juror role. I think that's clear from the record. That's the key fact that I alluded to at the beginning of my statement. So once the trial court decided to go down
let me ask you one more question before we get too deep into this, and that is, what is the effect of the 10B opinion upon this case in your analysis that you're walking us through?
Your Honor, the effect of the 10B opinion was that the trial judge has obviously been removed as trial judge, but the Court of Appeals, Judge Clement writing, made it clear that he was not deciding and had no jurisdiction to decide the efficacy or the effect of the trial judge's order, the May 2020 order, except as to the issue of recusal. That being the case, that issue, the effectiveness of that order, the effect of that order is still before the court. And our position is that that order is it's a fact. It's a legal fact. It's on the record. The court spoke and the court effectively belatedly granted our motion to alter and amend by stating on the record her reasons for granting the order. And that fact now existing needs to be taken into account. And our position is that it is taken into account by analyzing the new trial order in light of the judge's statement of her reasons for granting that order. And having stated those reasons, having exercised her discretion to grant a new trial on the basis of that particular error and solely on the basis of that error, her exercise of discretion needs to be evaluated in light of the governing legal principles. And those are the three I alluded to at the beginning that she simply did not address. And given her failure to acknowledge, address, and apply those principles, we submit it was an abuse of discretion, and that the order should be reversed and the jury's verdict and the judgment thereon reinstated. Did I answer your Honor's question?
Sort of. And I think it's because I didn't word my question as correctly as I possibly should have. So the 10B recusal, or the 10B opinion, recused the trial judge, said essentially there was an appearance of impropriety and that the rule required recusal. Do we have inconsistent findings here now that we have the trial judge's stated reason for why the motion for new trial was granted? How do we analyze those two competing interests? And maybe they're not competing. I don't know. It seems at first blush they are.
Yes, Your Honor. I think I understand your question. Let me take another whack at it. I don't think they're competing interests. As a matter of law, as a matter of principle, a trial judge could take an action that was lawful, but still created an appearance of impropriety. So in this case, the judge, an order granting a new trial is a non-final order. That's why we're before the court on an extraordinary appeal as opposed to an appeal as of right. So the trial judge, as a matter of law, had the right at any time to revise her previous orders. The trial judge had the ability at any time to state the reason she granted a new trial. We asked the trial judge to do that, and she denied that order, denied that motion, but subsequently she effectively granted it by stating her reasons. And she had the power to do that. What Judge Clement said in his opinion was it was the timing and the circumstances in which she exercised her power to state her reasons that created the appearance of impropriety. By waiting so long and by only stating her reasons when it was the only way to avoid being removed under Rule 5906, she created the appearance of impartiality. So what we have is a belated amendment of an order granting a new trial to elucidate us about the court's reasoning that, due to those circumstances, created an appearance of impartiality. So the Court of Appeals, finding that appearance of impartiality, ordered her recused, but we still have the legal and factual reality that the trial judge amended her prior order and stated her reasons for granting a new trial. Does that answer Your Honor's question?
I think so.
Thank
Thank
you. I want to, it is important to note that this case has now been pending. This case is now entering its, I believe it's 10th year. The second, it's gone through 2 jury trials. And both those jury trials were extremely well litigated. And I don't say that just to pat my side on the back. Our opponents litigated admirably. It was a well-fought trial, and all the evidence that could be put in a trial like this has been put in twice. And the first time the jury hung, and the second time the jury did not. And I think the question that illuminates it illuminates or emphasizes the harm here that's resulted from the trial court's failure to consider these basic principles. A party is not supposed to be given aces in the hole. So the sanctuary objected, and the trial judge was prepared to grant them what they later sought, a new trial. And they declined that. They expressly declined that and instead obtained a curative instruction. And they did so. And the other unique fact in this case is that we don't have to guess why the sanctuary did what it did. They stated it in their papers. It's in the record. They thought they were winning. This is precisely the situation that this court addressed in Harwell versus Walton. We cite it in our papers, but I think it's worth reading. A party may not save an infirmity in the proceedings as an ace in the hole to be used in case of an adverse decision or suppressed in event of a favorable decision. That's precisely what happened here. They held on to that as a card to play in case their bet that they're winning didn't pan out. And that fundamental unfairness is what I think is the key to understanding why this was an abuse of discretion by the trial court, not to take that into account, not to take those governing legal principles into account. I do want to address one final point that was raised in Appellee's brief, which is all the case law we cited does come up in the context of appellate cases, appellate courts deciding that various trial errors were waived at the trial level. And our response to that is, sure, that's typically the context in which these principles are elucidated. But there's no authority and no reason to believe they don't apply at the trial level, and that a trial judge should not take those into account. I mean, trial judges regularly apply principles of waiver in conducting trials, and it's really built into the DNA of the law that a party has to make choices. Here, the sanctuary made a choice, and as a matter of fairness, and as a matter of judicial economy, and as a matter of principle, they should be held to it. So we ask the court to reverse the trial court's order granting new trial and to reinstate the verdict and judgment thereon. Thank you.
Thank you. Well, you've got your rebuttal time. We'll now hear from the appellee.
Yes, and Good morning. May it please the court, I'm Mark Bell, and I represent the appellee, the Elephant Sanctuary in Tennessee, along with Bob Boston. Your Honor, the current appeal should be dismissed, and the case should remain remanded as this court previously affected by mandate on October 5th, 2020, to be tried before a new judge. To the point, Judge Stafford, you were making earlier, ultimately, that is what should have happened, and that is where we are now after the Rule 10b order. Ms. Buckley's appeal under Rule 10 application should be dismissed really for 4 independently sufficient reasons. The first is the standard for Rule 10 has not been met here, and the Elephant Sanctuary didn't waive any rights. Second, Ms. Buckley's request is moot, as she's already obtained the alternative relief that she sought. Third, the law of the case from the 10b opinion dictates that the trial court granted the motion for new trial under 5906. And fourth, the trial court's ruling indicates the motion was granted because it was in the interest of justice to do so, and the court did not expressly rebut the presumption that Rule 5906 was a separate and independently sufficient ground for granting the motion for new trial. As far as the first element, the standard for granting a Rule 10 extraordinary appeal application, it's not been met here. And the Rule 10 extraordinary appeal application—
Do you get to relitigate that?
I'm sorry?
Do you get to relitigate that issue?
Well, we're here before you because it was granted as far as to be able to hear the question on the Rule 10. And I think that now that we've had additional briefing on it and additional briefing and information on it, that it's clear that in this particular case, there was not an abuse of discretion. There was not arbitrary and capricious review, or there was not an arbitrary and capricious decision by the trial court. So that's really the point that I'm getting to, is that
I've seen Rule 10s being dismissed after the court has taken them as being improvidently granted, but I've never seen it as an issue that was actually raised. And that doesn't mean anything other than I haven't seen it.
I understand. And really the point is on that the trial court was clearly within its discretion in granting the motion for new trial. And that's the ultimate question, is whether the trial court was in its discretion, exercised its discretion here.
Let me ask you, Mr. Bell, are you saying we can't review that decision to grant the new trial?
Well, what I'm suggesting is that the decision to grant the new trial, that's subject to review by this court, but I believe that's already been decided by the court in the Rule 10b appeal, and where we could potentially have an inconsistent result if there's a different finding in this particular case.
So explain to me how the 10b decided that. I'm having difficulty connecting the dots there. Sure.
And so I think the opinion, there's certain parts in the opinion that I think are relevant there and address that specifically. On page 5 of the opinion, the court says, as an initial matter, we agree with Ms. Buckley's assertion that in the absence of an explanation for granting a new trial, Rule 5906 required the trial judge to recuse herself. On page 6 of the opinion, it says, accordingly, if the trial judge does not give a reason for her action, the appellate courts will presume she did weigh the evidence and exercise her function as the 13th juror. And then finally, on page 9 of the opinion, and I think this is the critical component of it, says, as Ms. Buckley contends, the trial court only stated a reason for granting new trial after, and that's bold in the opinion, Ms. Buckley invoked her right under Tennessee Rule of Civil Procedure 5906 to have another judge preside over the new trial. And so in the opinion, it's clear that Ms. Buckley invoked her right under 5906, because that's what applied in that situation, that there's a presumption that was not rebutted, and that it was only after the Rule 59, Ms. Buckley exercised her rights under 5906 that the trial court then expressed additional reasons for the opinion.
Was that an additional reason, or was that the reason?
I would submit that was, she did say that was the reason. I would submit that she didn't say this was the only reason that I'm granting it. And I would also submit that she didn't expressly address Rule 5906 in her opinion. It was the response, her response, as the court pointed out in the Rule 10 appeal, was that it was in response to the motion to recuse, not in response to the motion for new trial. So in response to the motion for recuse, she stated that was the reason in response to that particular motion. But the trial court was well aware that there's a presumption that is granted under 5906, and the trial court never did rebut that presumption or say that she had weighed the evidence and found the evidence was sufficient to support the verdict in this particular case. I would also submit that the trial court did not distinguish or differentiate between whether she was granting it under the fact that counsel's arguments in closing, or counsel's comments in closing argument can be itself an independently sufficient ground for granting a new trial, as well as the interests of justice that can go to the aspect of the interests of justice. And I don't think there's any allegation that the Elephant Sanctuary did, or whether it even could, waive the right to assert that the interests of justice required granting a new trial. And I think here it was very clear from the judge.
Under your analysis there, Mr. Adams mentioned that the trial court didn't act as 13th juror in this situation, that the trial court didn't weigh the evidence as 13th juror. The trial court ruled that when the trial court explained its decision, it gave its reason, but it's the same reason that it gave the curative instruction. So trial court's not acting as 13th juror here in the interest of justice. Can the trial court grant the motion for new trial in the interest of justice as you're proposing? And if so, what capacity is it acting in, as the trial judge or as the 13th juror?
Yeah, and I believe that the trial judge can do it under the interest of justice under Rule 59.07. And I believe in that situation, that's not necessarily, and probably in this particular circumstance, is not doing so in the interest of justice as the 13th juror. I think it's a separate inquiry and separate question for the trial court. And there's but to say that the trial judge didn't exercise her function as a 13th juror, I think would be incorrect, because trial judges are required to do that as a matter of law, to determine that as a 13th juror. And so if the trial judge hadn't, as submitted by appellant, then I think there needs to be remanded for a determination of whether the trial judge was exercising or had considered that or made that decision. But I still don't think that there's anything.
How could that be done logically, since the trial judge is now recused?
Well, if it was remanded for additional findings of fact and conclusions of law in response to that, and it was remanded to then the prior judge for additional findings of fact and conclusions of law on that particular point, procedurally, I think it's complicated, but I think the procedure in this particular case is complicated already. In this case, the case has been remanded, and a mandate's been issued to remand the case for trial before a new judge, and that process is underway. A new judge has been appointed, and so if it can't go back to the trial judge to then determine whether she had or had not rebutted the presumption that it was under 59.06, and it's not possible to do that, then I think that presumption stands, and then it would have to be determined under 5906 that she did exercise her rights as a 13th juror.
Let me ask you, Mr. Bell, I'm struggling a little bit with why the argument about taxes somehow affected the jury's verdict. The issue in this case was about ownership of the elephant. So Mr. Yarbrough's argument about what's permanent, poorly developed, but corrected, why would that affect the outcome in considering the issue of ownership? And we also know from the first trial, where there was no argument about taxes, the jury verdict was 11-1 in favor of Miss Buckley.
And so I think that those sort of two of those actually go hand in hand, in that the reason that the interests of justice are so heavy here, and the reason that it mattered in this particular case, although not necessarily directly germane to the ultimate issue, is because the trial court had warned both sides about bad facts on each side, things that are necessarily harmful to each side and prejudicial to each side, and things that are going to tug at the jurors' heartstrings improperly for each side.
Well, let me ask you, I think Mr. Boston argued in his opening that the sanctuary was non-taxable. I mean, I don't understand what the payment of taxes has to do with the issue of ownership and how that was so egregious and prejudicial.
And
There should be a new trial.
So I think there's an important distinction between a tax exempt for the purposes of paying federal taxes and the fact of not paying property taxes in the community of Hohenwald. And so I think the point the judge was making is that in the community of Hohenwald, people have a hard time with the fact that this large organization with all this land is not paying property taxes in that particular community. And so that's what's prejudicial and harmful, and is what people have sort of already a negative aspect, negative feeling, negative belief towards the sanctuary. And so it's designed to say the sanctuary is not doing its fair share in this community that's been hard hit and is struggling. The sanctuary is not doing anything. And so or not paying its fair share. And that's different, I think, than it relates to federal taxes and whether the sanctuary is paying federal taxes or not on the money, because I don't think that was an issue for the populace of Hohenwald.
But in the curative instruction, not only did the trial judge say, don't consider that argument by Mr. Yarbrough, but the trial court also went on to say that the sanctuary does pay taxes. And so the jury would have known that before they deliberated.
Yes, and I do agree with you. The jury would have known that, but that's again why it goes to the question of the interest of justice. And the interest of justice, and sort of to the second point that you had raised, Judge Armstrong, is that the judge was also upset because the number 11-1 came out because the judge had disclosed that information also. And so that was why the interest of justice weighed so heavily on granting the new trial, and what made granting the new trial be the right thing to do was because the interest of justice had been violated by taking confidential information, not once, but twice, that the judge had provided to each side for their benefit and use going forward, and then use that for a strategic advantage in the case, and then use it as strategic advantage in further pleadings. And the judge expressed that during her comments that are in the record, also through pages 997 through 998 of the record, where the judge explained why the comments were so egregious and why she felt like the interest of justice had been violated here by taking that confidential information that was provided by the trial court and then using that confidential information for strategic advantage. And I think it's clear that she was weighing that on the interest of justice side and granting the new trial because the interest of justice required it to be so.
Maybe I'm confused, but as I understand it, the statement about the vote of 11-1 was in connection with an argument before the trial judge. That was not disclosed to the jury, was it?
No, that's correct. That was not disclosed to the jury at any time. Absolutely not. If I indicated that's not my intention. But she was saying that basically, that strategically in the case, not before the jury in that particular instance, but strategically in the case, had used that information for a strategic advantage.
Well, let's just look at the 13th juror aspect. I mean, if you look at the testimony, what proof would the trial court rely on to make a determination that the jury reached the wrong decision? Because you don't have a single witness that says that Ms. Buckley transferred ownership. In fact, your CEO said this case is not about ownership. It's about the best interest of the elephant. But the case is about ownership. But your witness, your CEO, says it's not about ownership. She wasn't even claiming that the sanctuary owned the elephant. They just thought it was not in the best interest of the elephant to be transferred to another facility. as I
And
understand it, looking at the transcript.
Yeah, and if I may respond to your question, I realize I'm out of time, but if I can respond
You
briefly,
can
I think
answer his question.
there's 2 points to that, and there's 2 issues. One is that under 5906, if the judge doesn't state exactly why or what aspects go into the weight of the evidence, then there's a deference to the trial court. The second one is in the evidence and in the record. There was the interrogatory signed by Miss Buckley said that this policy, the disposition policy, applies to Tara the elephant. And then the question on the jury verdict is whether the policy does in fact apply to Tara the elephant. And so there's really only one reason, one valid way that the trier of fact could read that to say if Miss Buckley admitted in her interrogatory that this policy, disposition policy, applies to Tara, and the jury verdict question asked, does this policy apply to Tara? There's only one reasonable way to read that verdict.
All right.
All right, sir. You have used your time. We will hear rebuttal from the appellant. You have 2 minutes, I believe.
May it please the court, I'm Ed Yarborough, and I did want to have a couple of minutes at the end to say that I'm the one that made the mistake here. I was 75 when we tried the case. I'm 77 now, so Mr. Adams would only give me 2 minutes. But the point I wanted to make in rebuttal is that the ace in the hole argument is not only correct, but I believe that your Honor's questions have pointed up something else, and that is this: that when the sanctuary had the opportunity for a mistrial, they could have taken it, and there would have been nothing we could do. They chose, for tactical reasons, not to take it, and the verdict went against them. Then, when the judge had the opportunity to rule as a 13th juror, and there would be no appeal from that, but knowing that she would have to leave the case, we can't know what the judge was thinking, but the judge finally, after a lengthy delay, ruled that her sole reason for granting new trial was the error in argument. That essentially gives them not 2 bites at the apple, it gives them 3. And we believe that even though the courts have held multiple times that you can't keep an ace in the hole, we think it's beyond peradventure of doubt that they can't keep 2 aces, that they can't say heads I win, tails you lose, both at trial and in the appellate court. And so that may seem simplistic. Mr. Bell is correct. It is a complicated case, but oftentimes complicated cases can be decided on just plain law. And I appreciate the court listening to me for the last 2 minutes.
Thank you, gentlemen. We appreciate your argument. We appreciate your briefs, and we will take it all under consideration, and we'll endeavor to get you an opinion in this matter at the earliest possible time. We appreciate you participating today. Stay safe, stay warm, and thank you again. Mr. Hibner, if you will recess court to the call of the next case.
This honorable court is now in recess until 10 a.m.
Thank you.
Thank you.